by failing to faithfully execute the law. I want to ask you this. You issued a memo directing in certain circumstances that your AUSAs and USAs not inform the grand jury and therefore not inform the jury and therefore not inform the judge about drug amounts.
About drug
amounts in Title 21 cases.
I'm sorry, drug
amounts.
Drug amounts, I'm sorry. Go ahead.
Right. It's a memo. In cases involving Title 21 mandatory minimum sentences based on drug type, prosecutors should decline to charge the quantity necessary to trigger mandatory minimum. General Holder, we already have a safety valve. Congress has already passed a law that if you meet these requirements, the mandatory minimum is not applicable. So why would you eschew what Congress has done and trump it with a memo? Well, I mean, I'm really honestly trying to understand how you can respect the law and disrespect a statute that Congress has already passed.
Well, ultimately, I'm trying to do is to push discretion in the hands of the men and women who serve as assistant U.S. attorneys to look at the defendant who is in front of them and make an appropriate determination based on the conduct of that person what an appropriate sentence is.
How do we explain waivers and exemptions and delays in a bill passed by Congress and affirmed by the United States Supreme Court? How do we explain away a refusal to enforce mandatory minimums that were passed by Congress and affirmed by the Supreme Court? And why pursue, Mr. Speaker, immigration reform if presidents can turn off the very provisions that we passed? You know, in the oath that brand new citizens take, it contains 6 different references to the law. If it's good enough for us to ask brand new citizens to affirm their devotion to the law, is it too much to ask that the president do the same? If a president, Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that in some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecutorial discretion. Wherever the line is drawn, it's got to be drawn somewhere from here. It can't include categorical rejections of the application of the law to millions of people.
If a president can change some laws, can he change all laws? Can he change election laws? Can he change discrimination laws? Are there any laws under your theory that he actually has to enforce? What is our recourse, Mr. Speaker? What is our remedy? Some would argue the framers gave us the power of the purse and the power of impeachment, but Mr. Speaker, those are punishments. Those are not remedies. What is the remedy if we want the executive to enforce our work? But I would just tell you that I always thought prosecutorial discretion was an individual prosecutor determining whether she or he has enough facts to substantially result in a conviction on a case-by-case basis. If a president is ignoring entire categories of the law, whether it be immigration, marijuana, mandatory minimum, the ACA, what is the remedy for the legislative branch?
Well, first of all, the first part of that question is, as you may know, I do criminal defense work. I would never go to a prosecutor and say, I want your prosecutorial discretion to say that the entire class of which my client belongs cannot be subject to this law, because prosecutors would look at me and say, are you insane? I am not Congress. So I wouldn't even raise the question. Now, in terms of where we go from here, I'm not too sure, because the great concern I have for this body is that it's not only being circumvented, but it is also being denied the ability to enforce its inherent powers. Many of these questions are not close in my view. The president is outside the line. But it has to go in front of a court, and that court has to grant review. And that's where we have the most serious constitutional crisis I view in my lifetime. And that is, this body is becoming less and less relevant.
Mr. Speaker, we are not held in high public esteem right now. Maybe members of Congress would be respected more if we respected ourselves enough to require that when we pass something, it be treated as law. Maybe we would be more respected if we had a firmly rooted expectation that when we pass something as law, it be treated as law. Maybe we would be more respected if we put down party labels and a desire to keep or retain or acquire gavels and picked up the history, the tradition, and the honor of this, the people's house. Mr. Speaker, the House of Representatives does not exist to pass suggestions. We do not exist to pass ideas. We make law. And while you are free to stand and clap when any president comes into this hallowed chamber and promises to do it with or without you, I will never stand and clap when any president, no matter whether he's your party or mine, promises to make us a constitutional anomaly and an afterthought. We make law. Nell Lindsay was a nurse at a local hospital. Her shift had ended and it was time to go home. She couldn't take her own car because her husband had disabled the car so it wouldn't work. This is the same husband who had broken her jaw on a family vacation. The same husband who had knocked out her teeth in an Applebee's parking lot while her children watched. The same husband who had called their oldest son a sexual orientation epithet and put beer in the baby bottle of their youngest child. So Nell Lindsay got a ride home from the hospital from work with a friend of hers. And as they were headed home, they saw an ominous sight, Madam Chairwoman. They saw the car of her estranged husband. Now, he had been ordered to stay away from her, Madam Chairwoman, but he didn't care. And there was a condition of bond to stay away from her, but he didn't care. And there was a court order, an order of protection to stay away from her, but he didn't care. And when Nell Lindsay and her friend saw that ominous sight of Marion Lindsay in a car, they did a very smart thing, Madam Chairwoman. They headed straight for the Inman Police Department. And they're jumping over railroad tracks, and they're running stop signs, and they're running red lights. And Nell gets out her cell phone, and she calls 911. And she says, "Please help. Please help." So they pull into the back parking lot of the Inman Police Department, and she still has the cell phone to her ear. And through the audio tape that we played at trial, Madam Chairwoman, you could hear Nell Lindsay saying, "Please help. Please help." And then you heard 4 gunshots. And when they took her body out of the back seat of that car, she still had the cell phone in her hand. The system failed Nell Lindsay, Madam Chairwoman. She did everything we tell battered and abused women to do. The courts couldn't save her. The prosecutors couldn't save her. Her husband's on death row, but that doesn't save her. But even in her death, Madam Chairwoman, she did something good because she spawned changes in South Carolina in the way that we treat violence against women. And with the help of Violence Against Women grants, like the ones that are at jeopardy today, with the help of those grants, and a woman named Lynn Hawkins, who I must concede, Madam Chairwoman, does not share my political ideology in any way, shape, or form. But she put the political sloganeering and the bumper stickers behind. And she said, "Let's change the system in South Carolina," and we did it. And it wasn't in time to save Nell Lindsay. but it was in time to save a graveyard full of other women in our state. So I'm going to ask simply this, Madam Chairwoman. Can we stop the election year gimmicks? Can we stop these manufactured wars that pit one group of Americans against another group of Americans? I spent 16 years prosecuting men who raped, stabbed, strangled, shot, and killed women. I have a mother, a wife, a daughter, 3 sisters, and the images of countless women indelibly imprinted on my mind because they were killed by men who claimed to care about them. This is not about politics to me, and I will not yield. I will not yield. If you want to make women safer, then change the way we draw juries, change the discovery rules, improve the rape shield statute. But stop focusing on November's election for just one afternoon and wonder with me what good we can accomplish if we will stop the political games and if we could pick up some humanity and embrace the fact that even in a political environment as dysfunctional as this one, we can find common ground when it comes to fighting for those who have no voice, who have nobody to stand up for them.
Thank you, Mr. Chairman. Mr. Holder, Assistant Attorney General Ronald Weich wrote a letter to a member of Congress February 2011, a letter which was demonstrably false. Your department withdrew that letter 10 months later. When did you learn that that letter was false?
Well, I would not characterize the letter as false. I'd say it contained inaccuracies.
Well, Mr. Attorney General, it contained material, demonstrably false statements. Agreed?
I would say that it was inaccurate.
What consequences can we expect because of false statements made to Congress?
Well, as I said, there is an Inspector General investigation that is underway. I'll look at the results of that investigation, but I'll also be looking to see what happened with regard to the creation of that letter, if there's any more information that I can glean on my own before making determinations as to how people will be held accountable for the mistakes that they made.
Mr. Attorney General, it just seems to me that the policy is now going to be, let's get the least knowledgeable person that we can to write the letter. I found the exchange between you and Chairman Sensenbrenner to be interesting on mens rea. The defense is that Mr. Weich didn't know what he didn't know, so we're going to get the least knowledgeable person in the Department of Justice to write the letters to members of Congress. Is that what we can expect from now on?
No, what you could expect from this Department of Justice, as long as I'm the Attorney General, is that we will do our best to get you accurate information as quickly as we can.
Well, what I'm trying to get at, your defense of your friend Lanny Brewer, I guess at some level, is admirable. I just don't understand it. It took me a minute to get you to admit that he knew that guns were being walked, and there are scores of emails where he admitted it. He assigned a prosecutor to Fast and Furious. This is someone who on his own website boasts of being one of the best 100 lawyers in America. He knew that guns were being walked. He assigned a prosecutor to Fast and Furious. He forwarded an email to his home computer of a draft of Mr. Weich's letter. And he's going to stick around, Mr. Attorney General?
Well, you're saying things here, see, but you're doing what I asked you to not do before. That is conflating things. I said he knew about, and he admitted that he knew about gun walking when it came to Operation Wide Receiver.
Well, Mr. Holder, the letter is very specific. ATF makes every effort to interdict weapons that have been purchased illegally and prevent their transportation to Mexico. Is that true or false?
That is not accurate, but Mr. Brewer didn't, as he indicated, he said he did not have anything to do with the creation.
He forwarded this letter, a draft of it, to his home computer. Now, it does not take a long walk to get that he forwarded it to his home computer to read it.
I'm only going by what Mr. Brewer has testified to. which is that he did not think that he reviewed the drafts before they went out.
Who was Daniel Mudd?
He was the CEO of Fannie Mae during this period.
What was his total compensation?
I don't know off the top of my head, sir.
So you wouldn't disagree if it were $12 million?
That could be right.
How about Richard Siron?
He was the CEO of Freddie Mac.
During what time period?
I'm not sure, but it ended at the time of conservatorship.
Exactly, 2003 to 2008. Now, what was his total compensation for that time period?
Again, I'm sorry, sir, I don't know that.
Would you disagree with me if I told you it was more than $38 million?
I could believe that.
All right, so surely you can understand the frustration of taxpayers who are paying bonuses while the bus is driven through the gates of hell, right, and then you want us to pay bonuses while the people change the tires. Who was James Johnson?
James Johnson was the CEO of Fannie Mae prior to back in the 1990s.
And what was his total compensation during that time period?
It was substantial, sir. I don't know.
$100 million.
Right.
Now, he had a good working relationship with Congress, right?
Yes, he did.
Okay. Now, Franklin Raines, what was his total compensation?
I don't know, sir.
Would you disagree if it were more than $90 million? And he had a good working relationship with Congress. So right, sitting here simply saying that we need a better working relationship with Congress, one could argue that's what got us into this abyss.
I'm sorry, I don't recall saying having a better working relationship with Congress. I thought I said...
I've heard you mention the word Congress a half dozen times. And Mr. Chairman, if I could have 30 more seconds, the graveyard is full of people who are waiting on federal judgeships that never came. And I've heard the argument time and time again that we have to raise compensation levels for federal judges so we can attract the right kind of people. And yet every time there's an opening, there are 100 folks that are dying for it. They'll take a tremendous cut in pay. Now, I find it bitterly ironic that the total compensation for the United States Supreme Court justices is less than either of these two men made. So here we are again, Mr. Speaker, less than 6 months removed from last summer's so-called debt crisis, on the verge of committing another act of generational embezzlement. We are on the verge of assigning another $1 trillion of debt to our progeny because we can't muster the courage to make hard decisions. We're on the verge of $16 trillion in debt, Mr. Speaker, because we can't bring ourselves to say no. We're on the verge of $16 trillion in debt, Mr. Speaker, because we refuse to have a serious conversation about the role of government juxtaposed with the role of the individual. And in times like this, when leadership and moral courage, as my friend from South Carolina, Mick Mulvaney, so eloquently put it, when moral courage and leadership are needed, we get slogans more befitting of a student body president race than a campaign to be the leader of the free world. This administration says it wants a balanced approach, but a balanced approach apparently doesn't include a balanced budget. This administration says it wants a grand bargain, a big transformative deal, but the details of such a deal would fit nicely on the backside of a postage stamp. And my personal favorite, Mr. Speaker, this administration wants the, quote, rich to pay their fair share. I've heard that phrase several times this morning. What I have not heard, Mr. Speaker, because they never seem to get around to defining who the rich are, and they never seem to get around to defining the word fair, which may be the most subjective word in the English language. So I would ask, is it fair? Is 34% not enough? You want a half? You want 2/3?
Gentleman, yield for an answer.
When will your president define who the rich
will
are?
The gentleman yield for an answer?
And what's fair?
I'll be happy to answer the gentleman if the gentleman will yield. Will the gentleman yield?
The gentleman from South Carolina controls the time.
I didn't hear the answer. Will the gentleman yield?
The gentleman from Colorado will suspend. The gentleman from South Carolina may continue.
Thank you, Mr. Speaker. I hope the generations that come after us will have the courage the generations that came before us had, for we have been profiles in timidity and greed.
I think that the American people should know that the members of Congress are underpaid. A lot of members can't even afford to live decently when they have their job in Washington.
So what is your thought about a pay raise for Congress? And this is if I make a lot of friends on either side of the aisle, I'm sure, with your answer, whatever it may be.
You know, Greta, I know a lot of people in the world that are underpaid. In fact, I live with one who's a school teacher. But members of Congress are incredibly blessed and fortunate to have the jobs that we have. Nobody makes us run. Every 2 years, we offer for public office, and if you don't want to do it, then don't run. But the notion that you can make $174,000 in this country and be underpaid is laughable. We are better off than 99.9% of the people that we claim to work for, and I would be embarrassed to say that given our job performance and our salary, that we are anything other than grossly overcompensated. Public service means you give something up. You get compensation in other ways. You get the benefit of working in the Capitol, of being part of history, of being able to vote for your fellow citizens, all of which is priceless. So even if we were doing a great job, which no one believes, including our families and staffs, believe we are, we still don't deserve a raise. Because there are equally important jobs like law enforcement and firefighters and education and anyone who takes care of children who make far less. My wife makes a fifth what I make. My sheriff makes less than half of what I make. And they do a great job. So $174,000 is a lot of money, Greta, whether you're doing a great job or not so great a job. And look, there are members of Congress that I think earn their salary. I think, Jason Chaffetz, I'm a huge fan of his, Jimmy Jordan, Paul Ryan. There are lots of people that are in politics for exactly the right reason, but every one of them knows that you're going to give something up. If you think you can make more money in the private sector, then don't run for office. If you think you can make more money practicing law, then practice law. But don't run for office and then complain about the salary, because you know what it is when you file.
And I'll say this to the witnesses. I prepared a list of questions for all three of you. But during the ranking member's opening statement, as I shared with him on the floor, my mind went away from the questions, and I went back to South Carolina. In the very same month, the very same year that the IRS was conferencing in Anaheim, we were furloughing law enforcement officers. We were furloughing teachers. Prosecutors in my own office were furloughed. Secretaries in my own office were furloughed. Those are secretaries who struggle to make ends meet under the best of circumstances. And here we're asking them to go 2 weeks without pay, and we canceled all out-of-town training. We brought our own food to our Thanksgiving and Christmas office socials. We started an anonymous fund to help our fellow employees who were struggling to make ends meet. And one night, one of my secretaries came in after hours and asked if she could borrow the money to buy her child a birthday present. And she kept apologizing for having to do it. She kept saying, "I'll pay you back. I'll pay you back." And at exactly the same time, that young government employee, single mom, was borrowing money for a child's birthday present, other government employees were staying in $3,500 a night rooms. Other government employees were spending more money on promotional materials than that young woman makes in a year. And other government employees were spending more money on audience participation tools than that young woman makes in a year. So, Mr. Inspector General, I appreciate the work that you've done, but with all due respect, this is not a training issue. This cannot be solved with another webinar. This can't be solved with just one more recommendation. If we can just get that recommendation implemented, we're just one recommendation away from people acting responsibly. Mr. Inspector General, we can adopt all the recommendations you can possibly conceive of. I'll just tell you, it strikes me, and maybe it's just me, but it strikes me as a cultural, systemic, character, moral issue. The IRS has been in existence, depending on how you want to count, either since 1862 or 1918. But in either event, they've had 100 years to figure out that while your fellow Americans are losing their jobs and their health insurance and their homes, you do not spend $4 million at a conference for which there is no accountability. You do not hire people to make meaningless speeches or artists to paint paintings of Bono. When your fellow citizens, the ones who pay your salary, are struggling, that is a character issue. Training cannot fix that. They sent more than 25 employees on a scouting trip to see whether or not the hotel was okay. That's not going to be fixed with training, Mr. Inspector General. When you got law enforcement officers being furloughed and you've had 100 years to figure out how to act appropriately, you don't need an IG report to tell you that spending $27,000 for someone to talk about how random combinations of ideas can drive radical innovations, there's not a webinar in the world that's going to fix that. So, Mr. Inspector General, in reality, it just strikes me that we just need one single recommendation. Start over. This entity has not only targeted citizens that it was supposed to serve, it's allowed itself to be used as a political tool. Not only does it have access to our financial information, it will soon have access to our health information. Those are details that we don't share with people that we do trust. And we're going to be asked to share it with people who are so disconnected as to spend this amount of money while our fellow citizens are struggling mightily in the fall of 2010. I don't think training is going to fix it. I think replacement might.
Utah. Mr. Chairman, you have an absolute right to remain silent. No inference or suggestion of guilt may be inferred from your invocation of that right to remain silent. However, if you do testify or take the stand, you will be treated like any other witness and subject to cross-examination. Mr. Chairman, the reason that that phrase is running through my mind is because I heard it for 16 years. It's being repeated in courtrooms all across this country today, but not for powerful people that work for government, just for everyday folks. Just for everyday witnesses or everyday defendants of petty crimes, not charged with violation of constitutional rights, maybe just petty larceny. But they're being told you have a right to remain silent. However, if you testify or take the stand, you will be treated like every other witness. Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite, 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not. Mr. Chairman, she testified, I have done nothing wrong, I've broken no laws, or broken no IRS rules or regulations. That's her testimony. What I'm saying is we should have the right to cross-examine her on that testimony. Because I'd like to ask her, when you said we need a plan, who is we, and what plan are you referring to? When she said we need to be careful that it's not perceived as political, who is we, and what are you concerned about the perception of politics for? What are you fearful of, Ms. Lerner? She said, I think we really need to do a project. Again, Ms. Lerner, who is we, and what project are you referring to? That is a legitimate question. And every brother and sister at the bar on the other side of the aisle would ask that question on cross-examination if given the opportunity. Can you imagine, Mr. Chairman, can you imagine a fact pattern where somebody takes the stand and says, I didn't rob the bank? But I'm not going to answer why my fingerprints are on the demand note. And I'm not going to tell you why I'm on the surveillance footage with the gun in my hand. And I'm not going to tell you why the dye pack blew up in my car. I'm just going to tell you I didn't rob the bank. That's not the way our system works. You have to answer the other side's questions. I think these questions are fair. The Tea Party's very dangerous. Dangerous to whom? Who, Miss Lerner? Who thinks they're dangerous? You? The IRS? Dangerous in what way? We need a vehicle to get back to court. Who is we? Why do you want to get back to court? Could it, heaven forbid, be because you don't like Citizens United? Is that possibly the explanation? Mr. Chairman, she said Cincinnati should not have these cases, but then she turned around and said Cincinnati was to blame. That's an inconsistent statement. Every lawyer on that side of the aisle would ask her to explain that inconsistency. Everyone. So why can't we? If this isn't waiver, then can someone explain to me on the other side what fact pattern constitutes waiver? If you can make 17 separate factual assertions and authenticate a document and say, I have done nothing wrong, which is about as broad as any testimony can possibly get. I've done nothing wrong. I've broken no laws. I've broken no rules or regulations. I mean, honestly, what testimony could be broader than that? So necessarily, our cross-examination should be equally broad, and it would be in a courtroom. How often did you use your personal email, Ms. Lerner? That's a fair question. The Committee on Ways and Means just referred that issue to the Department of Justice. How many times did you use your personal email? When you mused about applying for a job with an organization connected with the president, were you kidding, Ms. Lerner? Or were you serious? Oh, we know you were contemplating retirement. Were you really seriously going to work? Mr. Chairman, I know my time is up. I'm just going to say this in conclusion. The same Constitution that allows her the right, if she wants to sit there and say nothing, allows these groups the right to petition their government for redress.
Judge,
well, I want to make it easier for you. How long will it take you to produce Lois Lerner's emails that don't involve 6103 material from January of 2010? Well, can we have that by Friday?
Absolutely not.
Why?
No way, because there's no way physically we can get
January of 2010. That's 1 month. No 6103 material. Just email.
1 month.
Just 1 month. When can we get that?
We have to go through each of those emails to make sure it has no 61.
Well, how long is that going to take? Can we have it by Friday?
I have no idea.
Just 1 month, Commissioner. January of 2010. No 6103. And let me tell you why I'm interested in it.
No, well, I'll tell you, today is Wednesday. I'd be happy to ask the people who do the work and get back to you.
All right, let's do January of 2010. And then let's get ambitious and do February of 2010. And then let's go March 2010. And I think you know why I'm doing 2010, Commissioner. When the president likes 5-4 Supreme Court decisions, he calls that settled law, like the ACA. When he doesn't like 5-4 Supreme Court decisions like Citizens United, he attacks it, which is what he did in January of 2010. And that's why the timeline is so important, Commissioner. The jury is never entitled to know the motive, but they always want to know the motive. You don't ever have to prove why somebody did something, but the jury always wants to know, why did this happen? And if you start in January 2010 with the President's State of the Union address, and then you move through Lois Lerner's emails that have nothing to do with 6103 material, you begin to see a motive develop.
Great. You're going to get 20,000 pages of documents this afternoon. Some of them may well be January 2010. But I will check with our people, because if you would like us to stop that production of Lois Lerner emails and go to January 2010, I will go and find out exactly how long.
What I want is this. I want the subpoena complied with. I want it complied with in a timely fashion. And you and I both know that if there's no 6103 material, whether or not you think we need something or we ought to have it, or that we're on a wild goose chase, frankly, I could care less what you think about that.
Mr. Schulman, when you learned that conservative groups were being targeted by the IRS for discriminatory treatment, what did you do?
When I learned of the existence of a BOLO list, in that same conversation or right around that time, I also learned a couple things. One, that it was being stopped. So that.
All right, and who told you it was being stopped?
That's Steve Miller, my deputy.
All right, and did you investigate further? Can you give me the name of a single person who was involved in the original decision to target conservative groups for disparate treatment?
I'm not aware of those names.
Why can't you give me a name?
So at the same time that I learned and that it was being stopped, I was also told that the Inspector General was aware of it.
Mr. Schulman, is the Inspector General the only person who can investigate wrongdoing within the IRS?
My general practice.
Can you answer my question and then you can explain? Is the Inspector General the only entity who can investigate wrongdoing?
Congress can investigate.
How about you? Can you do it?
The practice at the Internal Revenue Service that I inherited.
So if there's inappropriate conduct being done on your watch in the IRS, then that inappropriate conduct can last as long as the Inspector General's investigation lasts. Is that what you're telling me? That you're not going to step in and stop it?
No, what I'm telling you.
If there's someone wielding a knife in the parking lot, are you going to call the Inspector General? Are you going to wait until his or her investigation's over before you stop it?
When I was told about these allegations, I was also told that they were being stopped, and so that the inappropriate criteria were not being used anymore.
And despite the seriousness and potential criminality of that conduct, you didn't investigate it yourself at all?
So the procedures that I inherited and that my
Mr.
general
Schulman,
practice
this is going to go much quicker if you'll answer yes or no, and then you can explain. Did you do anything to verify that the practice, as insidious as it was stopped?
The Inspector General was going to be looking into it, and that's what.
Is it that you can't say yes or no, or you're just choosing not to say yes or no? Can you answer the question, did you do anything personally to make sure that this insidious, discriminatory practice was stopped? Yes or no?
At the time that I learned about it, I also learned two things. The first was that it was being stopped, and the second was that the Inspector
And what did you do to verify that it was stopped?
The responsible deputy of the Internal Revenue Service told me it was being stopped. I had no reason to believe otherwise.
Did you investigate why conservative groups were being targeted?
Excuse me?
Did you investigate? So you can't give me a single name. You can't answer the who. Can you tell me the why? Why were conservative groups? Why was the culture such under your watch that an employee felt comfortable targeting conservative groups? Did you investigate that?
You know, from my reading of the report, I can't tell if it was political motivation or if it was tone deaf, somebody trying to expedite a way.
You still don't know that this was political.
Excuse me?
You still don't know that this was political?
I defer to the Inspector General.
Well, I'll tell you this, Mr. Schulman. Your predecessor said that he wasn't sure if it was partisan, and that requires the listener to be as stupid as the speaker to utter a comment like that. He just testified that policy positions dictated this. What does that mean to you? If it's not partisan, what does that mean?
I'm not sure I heard that testimony.
Did you lift a finger to identify the facts?
Felt very comfortable. The facts, the Inspector General was going to run down the facts, and once he had it, it would be reported out.
Let the record reflect that's a no.
Collectively, Mr. Chairman, we all understand why people want to come to this country, to escape persecution, to taste freedom and liberty, to know that hard work and education and a level playing field can combine forces to transform lives. Escaping conflict and hardship is one thing, Mr. Chairman. Picking a new home is another. And America is picked because we are a country that embraces justice. We reward fairness. We're a nation of laws. the poorest of the poor has the same standing in court as the richest of the rich. We believe in the even application of the law because law provides order, structure, predictability, and security. And what we cannot become is a nation where the law is enforced selectively or not at all. And what we cannot become, Mr. Chairman, is a country where the laws apply to some of the people some of the time. The president from time to time, Mr. Chairman, says that he wants a country where everyone plays by the same rules. With respect, they aren't called rules in this country. They're called laws. And each of us takes an oath to enforce them, including those with which we may disagree. Because when the law is ignored or applied in an uneven way, we begin to see the erosion of the very foundation upon which this republic was built. And make no mistake, Mr. Chairman, as surely as today one may benefit from the non-compliance or non-enforcement of a law, that same person will be clamoring to have the law enforced in another capacity. So we seek to harmonize two foundational precepts, Mr. Chairman. Number one is humanity, and number two is respect for the rule of law. And history is whispering, as you noted, Mr. Chairman, that we have traveled this road before. In 1986, we were told that immigration had been settled once and for all. We were told that in exchange for secure borders and employment verification, those who entered the country illegally would not suffer the full panoply of legal consequences. In the minds of many, Mr. Chairman, the country got amnesty, but is still waiting 25 years later on the border security and the employment verification. So here we are back again, asking our fellow citizens to trust us. And many, despite ourselves, Mr. Chairman, remain open to legislative expressions of humanity and grace. But they will be watching, skeptically, to see if we are serious about enforcing the rule of law. Are we serious about ending the insidious practice of human trafficking? Are we serious about punishing those who prey on folks with false promises and fraudulent documents? Are we serious about border security and employment verification? Are we serious about making this the last time we have this conversation? Or are we simply playing political games with people's lives and undercutting the respect for the rule of law, which ironically is the very reason they seek to come to this country in the first place? We shall see. I yield back.
Thank you, Jimmy. We will not waver in our commitment to see that justice is done for this terrible act in Benghazi. And make no mistake, justice will be done. That was the President of the United States over a year ago. We're investigating exactly what happened. But my biggest priority now is bringing those folks to justice. That was the President of the United States over a year ago. No one has been arrested. No one has been prosecuted. No one has been brought to justice. We don't even have access to the witnesses. You and the media were good enough for my 16 years as a prosecutor not to tell me how to do my job. And so far in Congress, y'all have been good enough not to tell me how to do my job. I'm not telling you how to do your job. But I'm going to ask you some questions, and if you can't answer these questions, then I'll leave you to draw whatever conclusion you want to draw about whether or not the media has provided sufficient oversight. Can you tell me why Chris Stevens was in Benghazi the night that he was killed? Do you know? Does it bother you whether or not you know why Chris Stevens was in Benghazi? Do you know why we were the last flag flying in Benghazi after the British had left and the Red Cross had been bombed? Do you know why requests for additional security were denied? Do you know why an ambassador asking for more security days and weeks before he was murdered and those requests went unheeded? Do you know the answer to why those requests went unheeded? Do you know why no assets were deployed during the siege? And I've heard the explanation, which defies logic, frankly, that we couldn't have gotten there in time. But you know, they didn't know when it was going to end. So how can you possibly cite that as an excuse? Do you know whether the president called any of our allies and said, can you help? We have men under attack. Can you answer that? Do any of you know why Susan Rice was picked?
The Secretary of State did not go. She says she doesn't like Sunday talk shows. That's the only media venue she does not like, if that's true. Why was Susan Rice on the 5 Sunday talk shows? Do you know the origin of this mythology that it was spawned as a spontaneous reaction to a video? Do you know where that started? Do you know how we got from no evidence of that to that being the official position of the administration? In conclusion, Congress is supposed to provide oversight. The voters are supposed to provide oversight. And you were supposed to provide oversight. That's why you have special liberties, and that's why you have special protections. I am not surprised that the President of the United States called this a phony scandal. I'm not surprised that Secretary Clinton asked, what difference does it make? I'm not even surprised that Jay Carney said Benghazi happened a long time ago. I'm just surprised at how many people bought it.
Thank you, Mr. Chairman. Ms. Smith and Mr. Woods, I want to express on a personal level my gratitude and my sympathy to you for the loss of your sons, and to everyone that loved your sons and all the 4 victims of Benghazi. When you were testifying, I couldn't help but think of this dichotomy of death, that sometimes it walks slowly to the front door of your life, and it gives you plenty of time to get your affairs in order. You've had a good life. You have time to say goodbye to the people you love. You have time to offer a prayer for your soul. It just walks slowly and knocks gently on the front door. And then sometimes it kicks in the front door unexpectedly with no notice, and you don't even have time to offer a prayer. And the word closure is used all the time. In my experiences, it's only used by people who have never suffered the loss of a child, because there is no closure. I can't offer you closure. What I hope we can offer you is the truth, facts, justice, and let you do with that what you need to do as you walk down that road we call grief. So we can't give you closure. It's the facts, the truth. And the real jury, Mr. Woods and Ms. Smith, is the American people. They're the ones watching this trial unfold, and they will decide. They heard this morning a perspective that everything that can be investigated has been investigated. Everything. That's one perspective. The other perspective is you didn't even bother to interview some of the central key eyewitnesses. And the American people are going to have to decide whether or not they would ever tolerate an investigation where you don't call eyewitnesses and you don't call the people responsible for whatever the duty was. But I want to leave you with this. I want you to know this. From the upstate of South Carolina, I am asked about Benghazi more than any other issue. It has not been forgotten. I suspect you both live a long ways from the upstate of South Carolina. But just know, Republican, Democrat, Independent, don't know, don't care, from church to the grocery store to Costco, frankly to the golf course, I am asked about Benghazi and in effect about your sons more than any other issue. So the jury has not forgotten.
Good answer, please.
Yes, ma'am. I will work with Mr. Chaffetz, whom I agree with you on your characterization of, and the others. And frankly, there are folks on both sides who want to find out. And I appreciate the fact that Mr. Cummings has been here all day. I can't give you closure. I just want to give you the facts and the truth and justice and let you use it however you need to use it. Yield back. Thank you, Mr. Chairman. Mr. Chairman, for almost a year, there was an escalating pattern of violence directed towards the United States and other Western targets in Libya. Attacks on the consulate in Benghazi, attacks and assassination attempts on the British ambassador, attacks on the International Red Cross, attacks on courthouses, judges assassinated, culminating on September the 11th, and the murder of 4 Americans, including our ambassador to Libya. Before those 4 murders, Mr. Chairman, just a few weeks before that, our embassy in Libya said this to the Department of State: the security condition in Libya remains unpredictable, volatile, and violent. So, Mr. Chairman, despite what would appear to any reasonably objective observer as an escalating pattern of violence, including sophistication, coordination, and management, this administration blamed the murder of our ambassador and 3 others on a video. Don't take my word for it, Mr. Chairman. Let's look at what Ambassador Rice herself said. Our current assessment is that what happened in Benghazi was, quote, in fact, initially a spontaneous reaction. I don't know what the phrase in fact means in diplomatic legalese. I can tell you what it means in a courtroom, Mr. Chairman. It means it's a fact. And she went on national television and she said, not as this ambassador has said, that I'm not going to speculate.
But again, in the totality of looking at all the information that's been provided to this committee, we see the State Department trying to backtrack or cover themselves from not paying attention to warnings. The follow-on email was from David Adams. I'm with Toria, referring to Ms. Newland. The last bullet is especially will read to members like we had been repeatedly warned. Followed on, I spoke with Tommy. We'll work with this in the morning, get comments back.
She said, in fact, this was a spontaneous reaction to what had just transpired hours before in Cairo, almost a copycat of the demonstrations against our facility in Cairo, which were prompted, of course, Mr. Chairman, by a video, is what she said. And then she proceeds to say the attack was spontaneous. I can think of few things, Mr. Chairman, more antithetical to spontaneity than a 12-month-long prologue of violence in Libya. And then she said she relied solely and squarely on the information the intelligence community provided. Mr. Chairman, I would like to have another hearing where we can ask Ambassador Rice under oath, who told you what when? You're going to blame the intelligence committee? You come before this committee and you tell us who told you it was a video. Who in the intelligence community said it? Who in the diplomatic community blamed this on a video? And then we move to Jay Carney, who's the spokesperson for the leader of the free world. And this is what he said, Mr. Chairman. I'm saying based on information that our initial information that includes all information, we saw no evidence to back up claims by others that this was a pre-planned or premeditated attack. What we saw was evidence that it was sparked by the reaction to this video. And that is what we know thus far based on evidence, concrete evidence, close quote. Mr. Chairman, you know that in former life, I spent a little time in the courtroom. So when I hear the phrase concrete evidence, it means something to me. That's even stronger language than simply saying something is in fact. So 2 representatives of this administration gave demonstrably false statements, not just to us, but to our fellow citizens on national television. Now, is the explanation for those demonstrably false statements, as my colleague from Florida just asked, was it negligence? Was it just a reckless disregard for the truth? Or was it more nefarious than that? Mr. Chairman, the American people are reasonable. People understand investigations take time. People don't expect you to speculate until you have all the facts. What they will not forgive, Mr. Chairman, is being misled. We want our questions answered, and I want them answered by the people that went out before the American people and sought to mislead them by blaming this on a video when there is no evidence
concrete or otherwise, to support the assertions made by this administration. Mr. Chairman, I just had a conversation with Jason Chaffetz out back, and I hope he doesn't mind me saying this. He still gets emotional talking about what he saw in Libya. There were 4 brave Americans who died under circumstances that we can scarcely fathom. The terror, the fear, the anarchy of being killed in that fashion. They did what their country asked them to do. They stood post under dangerous circumstances even after requests for security were denied. They stood their post. The least we can do is stand this meager post that we've been assigned and demand that this administration speak the truth to the people it's supposed to serve. This was never about a video. It was never spontaneous. This is terror. And I want to know why we were lied to. And I yield back.
We'll now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Administrator Earhardt, if an agent stateside were soliciting a prostitute that was provided by a drug conspiracy he was investigating, what punishment would you recommend?
I can't recommend a punishment. I would just hope that would be thoroughly investigated. And
so you're telling me nobody cares what the administrator of the DEA thinks should happen to an agent? You're powerless to express your opinion. You have no First Amendment right when it comes to who works for your agency.
I have expressed my opinion in
What
a
was
number
your
of
opinion?
ways.
What did you express? What did you think the proper sanction was?
Last year, I sent email and I sent a memo to every employee in DEA and put them on notice that this kind of conduct was not acceptable.
My question must have been ambiguous because I wasn't talking about future conduct. I was talking about past conduct. What punishment did you recommend for conduct that happened in the past?
Under civil service law, I cannot recommend a penalty. I can't intervene in the disciplinary process. I can't even make a recommendation.
What does it take to get, what would it, hypothetically, what would it take to get fired as a DEA agent? Because the agents I used to work with were worried about using their car to go pick up dry cleaning. They were actually worried about using their OGV to pick up dry cleaning. They were worried about being disciplined. So apparently that world has changed. Do you know whether any of the prostitutes were underage?
I don't know that.
Would that impact whatever recommendation you might have in terms of a sanction?
I don't recommend the sanction. I can't fire. I can't recommend a penalty. There's a guide that the deciding officials abide by, and they have a penalty guide that they look at. And the penalty guide for this kind of activity is anything from reprimand to removal.
How about security clearance? Do you have any impact over that, whether or not an agent has a security clearance?
No, there's adjudicative guidelines, and that has to be adjudicated by the security people.
What power do you have? You have to work with agents over whom you can't discipline and have no control, and you have no control over the security clearance. What the hell do you get to do?
What I can do is build on and improve mechanisms to make sure that the outcome is what we believe the outcome should be. And that is what happened in Cartagena. That is what's going to happen moving forward.
Inspector General Horowitz, I find that stunning. Let me ask you this. Did the agents know that the cartels were providing the prostitutes?
What we found, Congressman, from looking in the file was that they should have known, given their trained law enforcement agents, and they were dealing with corrupt law enforcement, local law enforcement, that was providing them with the prostitutes as well as the various gifts.
Were they supposed to be investigating these cartels?
They were.
So they are receiving prostitutes from cartels that they are supposed to be investigating. And she can't fire those agents. You agree with her? She can't fire him?
I think as a matter of Title V, she can't directly intervene and fire them. I do think one of the concerns we outline in the report as to DEA and the other 3 agencies is how they adjudicate these cases. They undercharge them in some instances. And so at DEA, for example, sexual harassment, if you're charged with that, there's only one punishment: removal. But if you're charged with conduct unbecoming or poor judgment, which isn't even actually a category, then you've got a range of penalties. And so one of the issues, as you know as a former prosecutor, is how you charge the case. And that has a consequence.
Well, Mr. Chairman, I don't know what would need to be done, but I, like my friend from South Carolina, find it stunning that you can solicit prostitutes. Administrator Leonhardt, do we know whether any of the prostitutes were underage? Do we know whether any of them were part of any human trafficking rings?
Because the Bogota case happened a decade ago, there were no interviews of prostitutes. On the more recent one, the Cartagena one, it did not identify an age for the prostitute involved.
Mr. Chairman, I would just find it impossible to explain to any reasonable-minded person how an agent cannot be disciplined for soliciting prostitutes from drug cartels that they were ostensibly investigating. I find that stunning.
If the gentleman will yield, if somebody murdered somebody, could you fire him?
If someone murdered someone, there would be criminal charges, and that's how they'd be fired.
But if they were, could you take away their security clearance?
The Office's security programs can review security clearances and take their clearances just as they did with the 3 agents in the Cartagena incident.
Gentleman from South Carolina.
Gentleman, yield for just a second. I'm sorry, I heard you say that there's one thing you could actually fire somebody for, which is sexual harassment. So let me see if I get this correct, Mr. Horowitz, Mrs. Leonhardt. If I flirt with a coworker in the office and that constitutes sexual harassment, I can be fired, but I can take an underage hooker from a cartel I'm investigating and you can't fire me. Is that what we're talking about here?
Actually, Congressman, if you charge the offense, removal is a possibility. If you charge something less, conduct unbecoming or poor judgment, you don't charge what actually occurred, that's when the ability to discipline is limited. And that's the concern we found, as you know, in our report.
Thank you.
Thank the gentleman, both from South.
Thank you. Now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Director Clancy, do you believe Congress has a constitutional right to provide oversight over the Secret Service?
Yes, sir.
Do you believe that Chairman Chaffetz and Ranking Members Cummings are motivated solely by a desire to see what is best for the President and for the agency itself?
Yes, sir.
With those 2 thoughts in mind, does this committee have every single bit of video footage available from that evening?
I'm sorry, sir.
Does this committee have all available video footage from that evening?
It does not, sir.
Why not?
Sir, we have provided that footage, video that we have to this committee.
All of it?
We have shown 2 clips. We have not shown all of it.
That's not my question, Director. You just said that Congress has a constitutional responsibility to provide oversight. You just agreed with me that Ranking Member Cummings and Chairman Chaffetz have the best interest of the President and the agency in mind. So why wouldn't you not turn over all video footage to this committee?
Congressman, we will show all video at any time, day or night, that this committee would like to review the footage that we have. We have done that. In fact, the chairman was the first, I believe, to see this video before we showed.
With all due respect, that's not true. Go ahead, Mr. Gowdy.
No, I would
want. I'd like to just correct it. If I have to correct the record, I'd like to correct it.
I would like to yield to the gentleman from Utah because I was under the misapprehension apparently that this committee was not in possession of all available video from that night.
That's correct. They are not in possession of the video, but we did allow the chairman to view the video.
You've shown us less than 1 minute of video.
Yes. Yes, sir.
Well, back to my question. Will you make all available video? And I say available because we're going to get in a second to the fact that all of it was not preserved. Will you make all available video available to this committee?
We will make all video available to this committee for your review at any time, day or night.
Will you make a copy of it available so we can retain custody as opposed to simply showing it to us?
I will not release a copy of this video at this point.
Why not?
The OIG has an ongoing investigation.
Do you think the OIG's responsibilities supersede those of Congress?
Sir, I know that they have an ongoing investigation.
Well, can't you have simultaneous ongoing investigations? Why can't Congress provide oversight while the IG is investigating? Why do you have to pick and choose?
Sir, again, I think we have one initial investigation from the OIG, and we've given them the film to look at.
But you understand the responsibility of the IG is very different from the responsibility of Congress. Congress determines funding, among other things. The IG does not. So those two are not exclusive. Why can't Congress investigate what's in its jurisdiction while the IG does what's in its jurisdiction?
Congressman, I'm sure after the OIG's investigation.
I don't want to wait till after, because then that makes me think that you believe that Congress's constitutional responsibility to provide oversight is subservient to the IG. And surely to the Lord you can't believe that.
Sir, the ongoing investigation that the Secret Service has as well regarding the protective intelligence case. We have an individual who committed a crime, made a threat, and that investigation is also going on at this time within the Secret Service.
And how will providing that video footage to Congress jeopardize that ongoing investigation? With precision, how will it?
That video shows the actions of the individual who would be accused of a criminal act.
I get that. My question is, how will providing that to Mr. Cummings and Mr. Chaffetz jeopardize an ongoing investigation?
Well, again,
with specificity.
I am happy to show that video all day and be available at all hours of the day and night to show that video, but at this point we cannot release that video.
All right, that's the video that is available. The video that is not available, will you agree with me that there are at least 2 potential crime scenes at play on the evening of March 4th? At least 2. There's an assault on an officer and there's a suspicious package.
That's correct.
All right, why would the video not be preserved as part of that ongoing investigation that you just cited as the reason you can't give the video to Congress? Why wouldn't you preserve it?
The process, my understanding of the process is that the watch commander on site relays back the incident that he is the incident commander for, and he calls back to our Joint Operations Center and says, we do have an incident here, we have a suspicious package, preserve the video from this incident.
Director, I'm out of time, but I want you to consider for just a moment the dueling narratives that you had just portrayed.
Sir.
Number one, we're not going to give the video that does exist to Congress because its investigation is subservient to the IG investigation. That's narrative number one. And narrative number 2 is you're not even going to preserve video that could be used in a investigation of 2 potential crimes. Did I hear that right?
Well, we did preserve the video, the footage from the incident as those in the Joint Operations Center viewed it.
Well, right. But are you familiar with...
The gentleman's time has expired.
Well, some of my time was taken by the chairman, but that is the chairman's prerogative, and I would, of course, not ask for any more.
And the chairman obviously made the right ruling, so...
I yield back.
Good decision.
Chairman. That is perfect. Please restart the clock. Thank you. Some is recognized.
Some may disagree with that. I want to thank the gentleman from North Carolina for giving me his microphone. Mr. Jarvis, in October of 2011, Occupy protesters descended upon McPherson Square, and they decided to stay.
Despite the clear language of the law, these protesters camped at McPherson Square with the definition of camping being sleeping or preparing to sleep for 100 days. They camped in violation of the law, and you did not make a single solitary arrest for camping. So Congress decided to have a hearing and ask you why you were not enforcing the law. And you told us, Mr. Jarvis, that you had a great deal of discretion in how and when to enforce the law. You told us that you were, after 100 days of not enforcing the plain language of the statute, working with protesters to, quote, gain compliance, whatever the hell that means, with the law, and what you called, quote, a measured and reasoned approach. By the way, Mr. Jarvis, those were your words, not mine. So the law says no camping, but the protesters camped anyway, and you didn't do anything in terms of arrest or citations for over 100 days. So, Mr. Jarvis, I want you to fast forward 2 years. Parks are closing. Access to monuments is restricted, even access for those who helped build the monument in the first place. You didn't wait 100 days to enforce the law, Mr. Jarvis, with veterans who wanted to see their monument. You didn't work to gain compliance. Veterans weren't greeted with a measured and reasoned response, Mr. Jarvis. They were greeted with barricades on the very first day. Furthermore, they could not exercise their First Amendment rights to walk to a monument that they helped build, but yet some of our colleagues were allowed to exercise their First Amendment right to protest whatever it was they were protesting on the National Mall. So I'm going to read something to you, Mr. Jarvis. And I want you to ask me if you recognize who said this. Because of the lapse in funding, you are having to deliver difficult news to our visitors and partners. The functions we must perform under a shutdown are not the reasons any of us join the National Park Service, but they are the duties we are required to perform by law and regulation. Do you know who said that, Mr. Jarvis?
I believe I said that.
You're right, you did. So can you tell me why you would not enforce the law at McPherson Square, but yet you greeted veterans with barricades on the very first day? What regulation can you cite to me that required you by law to erect barricades?
The contingency plan that was approved on September 27th for the National Park System is in compliance with the Anti-Deficiency Act.
I'm looking for a statute, Mr. Jarvis. I am looking for a citation to the Code of Federal Regulation or the U.S. Code for why you erected barricades. We've established you did not enforce the law for 100 days for protesters. Agreed? You agree with me? You did not issue a single citation for camping, right?
I believe that is correct.
Either it is or it isn't. Is it? Not one single citation for camping.
I do not remember exactly.
Well, your previous testimony was that you had not issued a single citation for camping despite 100 days of noncompliance.
That was 2 years ago.
Okay, well, I can cite you the regulation that you did not follow 2 years ago. Can you cite me the regulation that required you to erect barricades to prevent veterans from accessing a monument that they built?
I can cite the Anti-Deficiency Act.
Can you cite a regulation that required you to erect barricades? Mr. Jarvis, that is not a complex question.
The Anti-Deficiency Act requires that I reduce all employees down to only those that are necessary for life and property. That required the closure of all 401 national parks.
Mr. Jarvis, why did you fail to enforce the plain language of a statute for 100 days for protesters? And yet, on the very first day, you denied access to a monument that veterans helped build.
On the very first day of the closure, I implemented a closure order for all 401 national parks in compliance with the Anti-Deficiency Act. And immediately that day, also included as a part of that order, that First Amendment activities would be permitted on the National Mall.
Do you consider it First Amendment activity to walk to a monument that you helped build? Or is it only just smoking pot at McPherson Square?
The First Amendment activities, we are content neutral on First Amendment on the National Mall.
That wasn't my question. Do you consider it to be an exercise of your First Amendment right to a walk to a monument that you helped build?
If an individual declares they are there for their exercise their First Amendment,
who were they to declare it to?
The gentleman's time has
expired. Could I ask the final question? Who were they to declare it to?
To
a
the
barricade?
ranger on the site. On the National Mall, any group under 25 does not need a permit to exercise their First Amendment. And we set up the policy to allow our veterans in, including all of the honor flights under First Amendment.
Get this question. You are opposed to immigration of persons south of the border coming to the U.S.
No, that's absolutely not true. I
Well,
support
let me
legal
ask-
immigration,
well, let-
not illegal immigration.
Well, let me ask you this question. You realize that we have been struggling with comprehensive immigration reform for many years in this country, and it is politics that keeps us from doing it, correct?
No, I think that
You don't think it's politics?
I think that
keeps us
it's
from doing it?
enforcement of the law. You may be dealing it.
Well,
from a
I mean, we're
political
talking
issue.
about changing the law so that we can have comprehensive immigration reform, but you are opposed to us doing that, correct?
The process, and I'll
Are you
share
opposed to us considering comprehensive
in the order
immigration
that you're doing it, yes.
Okay,
That the
because you
border needs
prefer
to be
that there
secured
needs to be
first,
border-
and then you can address that issue after.
All right, and that's a Republican position, Republican Party position, and you're a Republican, and I understand that. Let me ask you this question. Do you need automatic weapons to help you with border control?
We have in Arizona, through the chair,
If you could say yes or no, and then you could explain.
semi-automatic weapons.
Do you need automatic weapons?
We don't have to have automatic weapons, no.
Do you need mine-resistant, ambush-protected vehicles to help you patrol the border?
Not for the border, but for our SWAT team, yes.
Thank you. Do you need silencers in order to help you patrol the border?
For our SWAT team, that's a tactical move, but it's not necessarily targeted.
Why does
for
your SWAT
smuggling.
team need mine-resistant, ambush-protected vehicles?
Because, sir, through the chair, our county doesn't have the money to buy a SWAT vehicle.
Why do you need it in order to enforce border security? Why do you need a mine-resistant, ambush-protected vehicle?
And this is where.
Thank you. And do you need?
No, sir. Sheriff, you may answer the question. You cannot ask a question and then not allow the witness to answer it.
Mr.
Sheriff,
Chairman,
you
I
may
wanted a
answer.
yes or no answer. He answered the question, and I'm ready to move on.
Sheriff, have you
Now,
answered the
if someone-
question as completely as you would like to?
Mr. Chairman, I'm
The
ready
gentleman
to
is
move
not
on.
recognized. Sheriff, have you answered the question as completely as you would
this
like
is
to?
where us in
Mr.
law
Chairman,
enforcement.
regular order, please. Regular order.
In law enforcement, we have
Point of
420,000 residents of my county, and we are the SWAT team.
Point of
All
information,
13
Mr.
law
Chairman.
enforcement agencies, and for high-risk warrants, barricade
Chairman.
situations, almost never have we used
Chairman.
an armored vehicle for anything to
Point
do
of order.
with illegal immigration, Mr. Chairman.
Point of order, Mr.
Thank you,
Chairman.
Sheriff. The gentleman is out of time. If you have another question,
I have a point of order that I'd like to
state your
raise.
point of order.
Is it within the rules of this committee that the chairman can interrupt a legislator asking a question of a witness?
If that
Take
legislator
that
is not
legislator's
allowing a
time?
witness to answer a question, you daggum right he can. Yes,
Well,
sir. The
I
gentleman
take-
is out of
I
time.
take exception to the chairman's
The chair will now
abuse
recognize
of
the gentleman
authority
from Iowa,
as
Mr. King.
chair.
Thank you, Mr. Chairman.
I have been fascinated by, and not necessarily in a good way, by the evolution of the defense in this case. Mr. Chairman, initially it started when Lois Lerner disclosed this information in a fashion most calculated to be ignored, with a planted question at some boring conference. And then the second iteration of this defense was blaming two rogue agents in the Ohio field office. And Mr. Chairman, make no mistake, Jay Carney advanced and furthered that narrative, and he did so intentionally. You know, Mr. Carney's willingness to say, I don't know, is exceeded perhaps only by his willingness to acknowledge that he appreciates the question. But he didn't say, I don't know. He advanced the narrative that two rogue agents were responsible for this insidious discriminatory practice. And then we had colleagues that said this matter was closed. Months ago, Mr. Chairman, the matter was closed. And then the new iteration of the defense says, well, at least the White House isn't directly involved, as if that's the new standard for propriety in this town, that at least the White House directly didn't know about it. So that's our defense. And then the defense, Mr. Chairman, morphed into this, the most novel of all defenses, that the IRS is too poorly managed to be capable of concocting a scheme this sophisticated. That was the defense, that my client's too dumb to have committed this crime. And then, Mr. Chairman, we moved to the most recent defense, which is that, no, we didn't just improperly target conservative groups, we improperly targeted all groups. So while we may be guilty of improper conduct, we're not guilty of discrimination, because we did it against people at both ends of the political spectrum. So that's our defense. And now to see the Inspector General attacked. Mr. Chairman, there was an axiom in court that if you had the facts, pound the facts. If you had the law, pound the law. If you didn't have either one, pound the judge. And what's been said about Mr. George is reprehensible, and I can't wait till he has an opportunity to defend himself. But let me tell you what else is reprehensible, Mr. Chairman. Lois Lerner sat where those two witnesses sit today, several weeks ago. And these two witnesses put on a uniform and fought and defended this country and the Constitution so she could hide behind the Constitution and invoke her Fifth Amendment right, but only after she blamed them. She blamed two rogue agents in Ohio, and then didn't have the courage that these witnesses. I ought to just be thankful anytime IRS agents don't invoke the Fifth Amendment. I ought to be glad that anyone's willing to come before a committee of Congress and testify. Was Secretary Clinton aware of the attacks on Western targets in Benghazi leading up to September 11, 2012?
I believe our information.
I'm asking Admiral Mullen.
Was, yeah.
I'm asking Admiral Mullen.
I think she was.
She was aware of the attacks on Western targets. Was she aware that the British ambassador was almost assassinated in Benghazi in the weeks and months leading up to September 11, 2012?
I mean, I can't be positive, but I think she was.
Was she aware of the request for additional security at the Benghazi facility?
I would say no.
Was she aware of a specific request from the ambassador himself for improved security at that facility?
We never saw any request from Ambassador Stevens to.
That wasn't my question. Was she aware of it?
We never saw anything that indicated Ambassador Stevens asked for a significant upgrade at the facility.
Well, there's been testimony that he has. My question was she aware of that? Was the Secretary of State aware of it?
I don't know the answer to that.
All right. And here's what I found confounding about that. The 1998 ARB, you start your ARB with a quote from a Spanish-American philosopher about history, and those who don't study it are doomed to repeat it. And I found that interesting because the 1998 ARB recommended this: the Secretary of State should personally review the security of embassies and other official premises, closing those which are highly vulnerable and threatened. The Secretary of State, that was the specific recommendation from history. So you can understand, with all due respect to my colleagues who don't want to mention the Secretary of State's name, you can understand my question: did she personally review the security at Benghazi?
I don't know that.
all the evidence that we saw indicated no, but I don't know the answer to that.
Did she personally consider closing the facility in Benghazi? Again, given the fact that a panel exactly like the one you co-chaired recommended the Secretary of State personally review it. My question to you is, did she?
I'm not aware that she did.
So there is no evidence, despite a previous recommendation from an ARB just like yours, because what our colleagues on the other side say is, let's don't study the past, let's just look forward. You've made recommendations, all's going to be well now, all 30 of them will be implemented, and my point is, we had this recommendation. We had it in 1998, that the Secretary of State herself review the facilities and consider closing them if they are not safe.
I think one of the, and I think we have pulled people out where it wasn't safe over the course of that year.
But my question, Admiral, is you never interviewed the Secretary of State about whether she accepted and performed a responsibility given to her by a previous accountability review board. Mr. Holder, it is provable beyond a reasonable doubt, in my judgment, that Maine Justice had actual or constructive knowledge of gun walking, both in Fast and Furious and beforehand, and I'm going to prove it to you. March of 2010, DOJ, not U.S. Attorney's Office in Arizona, DOJ assigned a prosecutor to Fast and Furious. March 2010, Gary Grindler, who I believe is your chief of staff, knew about straw purchases and Fast and Furious and seizures in Mexico, and it doesn't take a very good prosecutor to ask how weapons got from Phoenix to Mexico. July 2010, a memo to you through the acting deputy AG. That memo specifically mentioned Fast and Furious. It specifically mentioned straw purchasers. It specifically mentioned 1,500 firearms supplied to Mexican drug dealers. That's July of 2010, 1,500 firearms. April 30th, 2010, a memo from Maine Justice employee Weinstein to Lanny Brewer. ATF let a bunch of guns walk. And then the rest of the email is worrying about the negative press connotations that may have come from that. Not how to fix the policy, but how to mitigate negative press consequences. October of 2010. Jason Weinstein and James Trusty swapped emails and specifically mentioned gun walking. And Mr. Attorney General, that email is so illustrative of our frustration with the notion that Maine Justice did not know about this. I'm assuming that James Trusty is a Maine Justice employee. Am I correct?
I believe that's correct.
All right. This is the email. And they're specifically talking about Fast and Furious. And in fairness, they also mention Laura's Tucson case. They say it's a tricky case given the number of guns that have walked. But it's a significant set of prosecutions. The email back to that is, I'm not sure how much grief we're going to get from gun walking. It may be more like people are finally going to say, we went after the people who sent guns down there. Now, lay aside the merits of that argument. How can you deny that people in Maine Justice knew gun walking was going on before that February 4th letter was sent to a member of Congress? That doesn't even get into the wiretap applications. That doesn't get to the factual predicate that a member of Maine Justice would have had to have read. All of this is before February 4th. That whole series of evidence predates Mr. White sending a letter to Congress denying the tactic. So my question to you is this. Who participated in the drafting of the letter?
Well, first, this is going to be one of those rare instances. You're right. There was knowledge within the Justice Department of gun walking. It was related to wide receiver. And
Mr. Attorney, with respect, I don't like interrupting people, but with respect, several of these emails specifically mention Fast and Furious. I'm not talking about wide receiver. Love to have that conversation some other time. Well, these emails and memos specifically mention Fast and Furious.
They mention Fast and Furious, but do they mention gun walking in Fast
Yes,
and Furious?
they do.
No,
That's my point.
I'd like to see those. Those I would like to see.
We got them from you. So, I mean, we got them from Maine Justice.
Let's do this. I've promised to give you all some information. I would really like to see a memo that says gun walking and Fast and Furious. I'd like to see that one.
Well, if you're looking for a videotape confession, I probably can't give you that. But what I can give you is an email from 2 Maine Justice employees back and forth, specifically mentioning Fast and Furious. It's a tricky case given the number of guns that have walked. I just find it stunning that you would want to avail yourself of the maximum departure from the guidelines that you can get for acceptance of responsibility and still sit here and not answer a single solitary question from a co-equal branch of government. Ms. Maloney asked a question that I thought was an extremely good question. Actually, she asked a bunch of really good questions, but I never heard an answer to this one. Is there a policy or procedure in place to investigate conflicts of interest between those who approve bonuses and those who receive bonuses? Not all at once.
The only requirement I know of, Congressman, is a financial disclosure requirement of all the senior officials.
So in theory, Mr. Brenner could be approving financial bonuses or other financial incentives for someone that he has a financial stake in whether or not they get more money. Is that within the realm of the possible? Because it certainly sounds like that's what went on.
Well, I'm not going to speculate on what's possible, but...
Why not?
Because I'm going to wait to read what the IG investigative report...
Well, if you're not going to speculate on what's possible, my next question is this. If Mr. Chaffetz or Jimmy Jordan told Chairman Issa that they weren't going to be here for a couple of weeks because they were CIA operatives, how would Mr. Issa go about verifying whether or not, and I'm going to be very clear, to date, neither Mr. Chaffetz nor Mr. Jordan have alleged that they're CIA operatives. But if that were to happen, how would Mr. Issa go about investigating whether or not that was true?
I can't answer that.
Well, the next person who claims it at your agency, how will you go about investigating whether it's true?
Under the current rules, as Mr. Sullivan pointed out, if there's an interagency relationship with that agency, the general counsel and the head of the agency would know.
So, what, a phone call?
I don't know what the process
is. That what we're talking about, Mr. Sullivan? A phone call to verify whether or not someone really is a secret agent with the CIA?
Well, I testified earlier, sir, that in 2008 a new directive came out, I think it's Intelligence Directive 304, which requires the Director of National Intelligence to inform the head of an agency and the agency's general counsel if one of their employees is working undercover for the CIA.
Mr. Sullivan, I appreciate that. And it really doesn't matter whether you're a new Earth guy or an old Earth guy, but 2008 just seems a little late to be figuring out that with one phone call you can decide whether or not someone who's claiming to be a spy and traveling first class and racking up $900,000 in unwarranted compensation really does work for another agency. Look, I understand technology has progressed a lot. 2008 just seems a little late for us to figure that out.
We have taken extraordinary steps to discuss this matter in ways that typically we do not.
Well, let me ask you this.
When charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any.
With all due respect, Madam Attorney General, you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally?
No, just as a prosecutor. There's involuntary manslaughter, there's reckless homicide,
There's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual steps of providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to, but right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did, or whether President Clinton could do exactly what Secretary Clinton did. I think that lack of clarity is bad for the Republic, quite frankly.
And Cappy, among many limitations in life is my inability to glean other people's motives or be able to read their minds. I could have sworn in response to a question you received from Mr. Cohen, you suggested race was the basis for why we may have this constitutional perspective. Did I understand you correctly?
I believe I was responding to the question about is there an explanation about why?
Well, let me offer another explanation to you, okay? Not a single Republican who is here right now ever served under a Republican president. Not one. So I hope I do live long enough to hold a Republican president to the exact same standard that I'm holding this one. But for you to run to race as the explanation for why we hold the position that we do. Harry Reid had a very different perspective on recess appointments when there was a Texan in the White House, and none of us accused him of geographic discrimination. In fact, hell, for that matter, Senator Obama had a different perspective on executive overreach than President Obama, and nobody runs to race as an explanation for that. So I would just caution you to be careful when you try to import motives to people.
Have all available video footage from that evening?
It does not, sir.
Why not?
Sir, we have provided that footage, video that we have to this committee.
All of it?
We have shown 2 clips. We have not shown all of it.
That's not my question, Director. You just said that Congress has a constitutional responsibility to provide oversight. You just agreed with me that Ranking Member Cummings and Chairman Chaffetz have the best interest of the President and the agency in mind. So why wouldn't you not turn over all video footage to this committee?
Congressman, we will show all video at any time, day or night, that this committee would like to review the footage that we have. We have done that. In fact, the chairman was the first, I believe, to see this video before we show it.
With all due respect, that's not true. Go ahead, Mr. Gowdy.
No, I would want.
I'd like to just correct it. If I have to correct the record, I'd like to correct it.
I would like to yield to the gentleman from Utah because I was under the misapprehension apparently that this committee was not in possession of all available video from that night.
That's correct. They are not in possession of the video, but we did allow the chairman to view the video.
You've shown us less than 1 minute of video.
Yes. Yes, sir.
Well, back to my question. Will you make all available video? And I say available because we're going to get in a second to the fact that all of it was not preserved. Will you make all available video available to this committee?
We will make all video available to this committee for your review at any time, day or night.
Will you make a copy of it available so we can retain custody as opposed to simply showing it to us?
I will not release a copy of this video at this point.
Why not?
The OIG has an ongoing investigation.
Do you think the OIG's responsibilities supersede those of Congress?
Sir, I know that they have an ongoing investigation.
Well, can't you have simultaneous ongoing investigations? Why can't Congress provide oversight while the IG is investigating? Why do you have to pick and choose?
Sir, again, I think we have one initial investigation from the OIG, and we've given them the film to look at.
But you understand the responsibility of the IG is very different from the responsibility of Congress. Congress determines funding, among other things. The IG does not. So those two are not exclusive. Why can't Congress investigate what's in its jurisdiction while the IG does what's in its jurisdiction?
Congressman, I'm sure after the OIG's investigation.
I don't want to wait till after, because then that makes me think that you believe that Congress's constitutional responsibility to provide oversight is subservient to the IG. And surely to the Lord you can't believe that.
Sir, the ongoing investigation that the Secret Service has as well regarding the protective intelligence case. We have an individual who committed a crime, made a threat, and that investigation is also going on at this time within the Secret Service.
And how will providing that video footage to Congress jeopardize that ongoing investigation? With precision, how will it?
That video shows the actions of the individual who would be accused of a criminal act.
I get that. My question is, how will providing that to Mr. Cummings and Mr. Chaffetz jeopardize an ongoing investigation?
Well, again,
with specificity.
I am happy to show that video all day and be available at all hours of the day and night to show that video, but at this point we cannot release that video.
All right, that's the video that is available. The video that is not available, will you agree with me that there are at least 2 potential crime scenes at play on the evening of March 4th? At least 2. There's an assault on an officer and there's a suspicious package.
That's correct.
All right, why would the video not be preserved as part of that ongoing investigation that you just cited as the reason you can't give the video to Congress? Why wouldn't you preserve it?
The process, my understanding of the process is that the watch commander on site relays back the incident that he is the incident commander for, and he calls back to our Joint Operations Center and says, we do have an incident here, we have a suspicious package, preserve the video from this incident.
Director, I'm out of time, but I want you to consider for just a moment the dueling narratives that you had just portrayed.
Sir.
Number one, we're not going to give the video that does exist to Congress because its investigation is subservient to the IG investigation. That's narrative number one. And narrative number two is you're not even going to preserve video that could be used in an investigation of 2 potential crimes. Did I hear that right? I have a plane to catch tomorrow afternoon. I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. Mm-hmm. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson. He didn't say that in 2008, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be.
We'll now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Administrator Earhardt, if an agent stateside were soliciting a prostitute that was provided by a drug conspiracy he was investigating, what punishment would you recommend?
I can't recommend a punishment. I would just hope that would be thoroughly investigated. And
so you're telling me nobody cares what the administrator of the DEA thinks should happen to an agent? You're powerless to express your opinion. You have no First Amendment right when it comes to who works for your agency.
I have expressed my opinion in
What
a
was
number
your
of
opinion?
ways.
What did you express? What did you think the proper sanction was?
Last year, I sent email and I sent a memo to every employee in DEA and put them on notice that this kind of conduct was not acceptable.
My question must have been ambiguous because I wasn't talking about future conduct. I was talking about past conduct. What punishment did you recommend for conduct that happened in the past?
Under the civil service law, I cannot recommend a penalty. I can't intervene in the disciplinary process. I can't even make a recommendation.
What does it take to get, what would it, hypothetically, what would it take to get fired as a DEA agent? Because the agents I used to work with were worried about using their car to go pick up dry cleaning. They were actually worried about using their OGV to pick up dry cleaning. They were worried about being disciplined. So apparently that world has changed. Do you know whether any of the prostitutes were underage?
I don't know that.
Would that impact whatever recommendation you might have in terms of a sanction?
I don't recommend the sanction. I can't fire. I can't recommend a penalty. There's a guide that the deciding officials abide by, and they have a penalty guide that they look at. And the penalty guide for this kind of activity is anything from reprimand to removal.
How about security clearance? Do you have any impact over that, whether or not an agent has a security clearance?
No, there's adjudicative guidelines, and that has to be adjudicated by the security people.
What power do you have? You have to work with agents over whom you can't discipline and have no control, and you have no control over the security clearance. What the hell do you get to do?
What I can do is build on and improve mechanisms to make sure that the outcome is what we believe the outcome should be. And that is what happened in Cartagena. That is what's going to happen moving forward.
Inspector General Horowitz, I find that stunning. Let me ask you this. Did the agents know that the cartels were providing the prostitutes?
What we found, Congressman, from looking in the file was that they should have known, given their trained law enforcement agents, and they were dealing with corrupt law enforcement, local law enforcement, that was providing them with the prostitutes as well as the various gifts.
Were they supposed to be investigating these cartels?
They were.
So they are receiving prostitutes from cartels that they are supposed to be investigating. And she can't fire those agents. You agree with her? She can't fire them?
I think as a matter of Title V, she can't directly intervene and fire them. I do think one of the concerns we outline in the report as to DEA and the other three agencies is how they adjudicate these cases. They undercharge them in some instances. And so at DEA, for example, sexual harassment, if you're charged with that, there's only one punishment: removal. But if you're charged with conduct unbecoming or poor judgment, which isn't even actually a category, then you've got a range of penalties. And so one of the issues, as you know as a former prosecutor, is how you charge the case. And that has a consequence.
Well, Mr. Chairman, I don't know what would need to be done, but I, like my friend from South Carolina, find it stunning that you can solicit prostitutes. Administrator Leonhardt, do we know whether any of the prostitutes were underage? Do we know whether any of them were part of any human trafficking rings?
Because the Bogota case happened a decade ago, there were no interviews of prostitutes. On the more recent one, the Cartagena one, it did not identify an age for the prostitute involved.
Mr. Chairman, I would just find it impossible to explain to any reasonable-minded person how an agent cannot be disciplined for soliciting prostitutes from drug cartels that they were ostensibly investigating. I find that stunning.
When you said they proposed it and that passed because the American people are too stupid to understand the difference.
When I said that, I was at an academic conference being glib and quite frankly trying to make myself seem smart by insulting others.
Are you offering the venue as a defense for saying it or for meaning it?
I'm offering it as a defense for using inappropriate and hurtful and inexcusable language to express.
Well, what did you mean by too stupid to understand the difference?
Congressman, I didn't mean anything by it.
Well, you said it. You had to admit it.
I was once again being glib and trying to make myself seem smarter by reflecting.
Well, what did you mean when you said it was a very basic exploitation of the lack of economic understanding of the American voter? What did you mean by that?
Once again, it's another example of my inexcusable arrogance in trying to insult others to make myself seem smarter.
Well, what did you mean when you said the American people don't care about the uninsured?
Once again, that was an overstatement of trying to conjecture on political topics in which I'm not an expert.
Well, you know what, Professor Gruber, I have listened to you all morning talk about your lack of political acumen and that you're not a politician, so therefore you don't know not to call people stupid. Most of the people watching this morning aren't politicians, and they don't call people stupid. And I can't help but note, Professor Gruber, and another one of your quotes, which I'll read to you, that was politically infeasible. You remember saying that?
Yes.
So you do like to factor in the politics from time to time, don't you? And also happen to know, Professor Gruber, that usually you insult the American voter, not the American public. So you do factor in politics, don't you?
I have tried a number of occasions, pretended that I know more about politics.
Do you think not being a politician is a defense? And is that your defense this morning? I mean, I know initially you said that you offered these comments at a conference. I think you meant conferences, plural, but you said conference when you went on a very obscure television show and initially apologized for what you said were inappropriate comments. And now today your defense is that you're not a politician. Is that the best you can come up with?
The best I come up with is to really just apologize for an inexcusable.
Well, but I want to know, I mean, the pervasiveness of your quotes is so much that it has to be more than that. It has to be more than just an episodic mistake that you made. Well, here, let me keep going. See if this helps you any. What did you mean when you said you wish that you had been able to be transparent, but you'd rather have the law than not?
Once again, it was my trying to conjecture about a political process in which I'm not an expert.
Well, what did you mean when you said it was written in a tortured way to make sure the CBO didn't score the mandate as a tax?
Once again, it was using inappropriate language to try to sound impressive about something to my colleagues.
Do you see a trend developing here, Professor Gruber?
I don't understand the question.
It's a lot of stupid quotes you've made. That's the trend.
a lot of
you see 'em?
inexcusable quotes. Yeah.
Right. And again, your defense is that you're not a politician. The lack of transparency is a huge political advantage. Well, what does a non-politician do in talking about political advantages?
A non-politician is talking about political advantages to try to make himself seem smarter by conjecturing about something he doesn't really know.
So you're a professor at MIT and you're worried about not looking smart enough?
Yes.
Okay. Well, you succeeded if that was your goal. Now, I want to ask you, are you sorry? When did you realize that these comments were inappropriate? Because it took you about a year to apologize, so I'm trying to figure out if you realized sooner that they were inappropriate, or was it just the morning before you went on MSNBC that you realized that it was inappropriate? When did you realize that these comments are indefensible and inappropriate?
I honestly didn't remember making them.
You didn't remember calling your fellow citizens stupid, and you didn't remember saying that you're the only person who cares about the uninsured, that the rest of your fellow citizens don't give a damn about the uninsured? You don't remember saying that?
I don't, because they were really glib and thoughtless comments that I made.
Well, Professor Gruber, let me just tell you what it looks like from this vantage point, is that you thought that they were really pithy and really funny until the video showed up. And then even then, it took you a little while to apologize. And what I'm struggling with is whether your apology is because you said it or because you meant it.